Start. The applicant of this interlocutory application was the original plaintiff who instituted a suit for declaration, specific performance, and possession of property and for permanent injunction. Stop. The suit was filed in 1988 and the written statement was filed by the defendant's respondents in 1989, contesting the claim of the plaintiff on merits but without raising any objection as to jurisdiction of the court. Stop. The jurisdiction of the court was admitted. Stop. The suit was then transferred to district court in 1993. Stop. In 1997, issues were framed which did not include issue as to the jurisdiction of the court. Stop. After more than 8 years of filing the written statement, however, the defendants filed an application under Order 6, Rule 17 of the Code of Civil Procedure seeking an amendment in it by raising an objection as to jurisdiction. Stop. It was contended that the suit was for recovery of an immovable property situated in Gurgaon. Stop. Under Section 16 of the Code, such a suit could only be instituted within the local limits. Stop. Since the property was in Gurgaon, Delhi court had no jurisdiction. Stop. The application was allowed and on the basis of the amended written statement an additional issue regarding jurisdiction was framed. Stop. Para. After hearing the parties, the trial court held that the suit was covered by Clause D, Section 16 of the Code, and the court in Delhi had no jurisdiction. Stop. The plaintiff was ordered to be returned for presentation to proper court. Stop. The said order was confirmed by the High Court as well as by this court. Stop. Para. In the present application, it was stated by the applicant that when he approached this court against the judgment and order of the High Court of Delhi, status quo was ordered to be maintained and operation of the judgment of the High Court was stayed. Stop. The additional district judge was allowed to proceed with the suit. Stop. It was, however, stated that the court would not deliver judgment until further orders. Stop. In pursuance of the said order. Stop. The trial court proceeded with the suit. Pleadings were completed, evidence was led, and the matter was ready for final arguments and disposal. Stop. It is further stated that an order was passed by the district court declaring that the defendant's evidence was closed and the suit was adjourned sine die in view of order of this court. Stop. This court finally decided the appeal, confirming the order passed by the trial court as well as by the High Court. Stop. According to the applicant, now the suit will have to be tried and decided by the Gurgaon court. Stop. He prays that since 17 years have passed from the institution of the suit and the pleadings are complete, evidence is reported, and the arguments are over, this court may direct the Gurgaon court to take up the suit from the stage at which it stands transferred and to decide it expeditiously. Stop. The application is resisted by the respondent by filing a counter. Stop. It is contended that the application is not maintainable as it is misconceived. Stop.